In this video, we will discuss the concept of murder as an offense under Indian legal system. It will be an analysis of the penal provisions and the procedural aspects. The first question that arises before us is, what is homicide? Murder is a homicide, and homicide means killing a man. There are two offences under the Indian Penal Code which deal with the killing of a man by another, and they are culpable homicide and murder. Culpable homicide is defined under section 299, while murder is defined under section 300 of the Indian Penal Code. The major difference between the two was given in the case of Re R versus Govinda, where the court found that there exists a difference of degrees of intention and knowledge. The culpability and gravity of offense of culpable homicide when compared with that of murder is much less, and therefore harsher punishments are given to those who are convicted of murder. Let us talk about section 300. Where section 299 lays down what amounts to culpable homicide, the section 300 provides for element which added to culpable homicide will amount to murder. We can also say that all murder are culpable homicides, but all culpable homicides are not murder. The key elements of murder are defined as culpable homicide with 4 additional elements. The additional elements will be explained to you in the subsequent slides. 1. The act is done with the intention of causing death. For example, a person administers a deadly poison to another. He is aware of the consequences and is evident that it shall cause death of the person. Same can be inferred from the case of Selvaraj as well, whereby intention was explained. Thus, wherever there is an intention of causing death, the act is considered to be murderous. The act is done with the intention and knowledge of causing such bodily injury which is likely to cause the death of the person. Here, special knowledge is put with the offender's intention to cause death. So, if a person knows that the other person is old and can be easily killed just by a small blow of iron rod, then it will be culpable homicide amounting to murder. Third, the act is done with the intention of causing such bodily injury as is sufficient in the ordinary course of nature to cause death. Here, the most eminent case is Vesa Singh versus State of Punjab, where the court pointed out 4 essentials. 1. There must be presence of a bodily injury. 2. The nature of the injury must be provided. These are purely objective investigations. Thirdly, it must be proved that there was an intention to inflict that particular injury which in ordinary course of nature will cause death, that is to say, that it was not accidental or unintentional, or that some other kind of injury was intended. The fourth element is that the act is done with the knowledge that it is so eminently dangerous that it must in all probability cause death, or such bodily injury as is likely to cause death. Here, the act is itself so dangerous that it will cause death inevitably. So if a person stabs another 15 to 16 times in the chest, then it will inevitably be the cause of another person's death. Exceptions to section 300 are 5 in number, and if any act of murder falls under these categories, then it will not amount to murder, but it will be amounting to culpable homicide. We will be explaining these explanations in the subsequent slides. The first exemption is of grave and sudden provocation. The K.M. Nanavati case is a major case in this exception, and the Honorable Supreme Court has also laid down certain essentials for this. The first essential being A. The provocation is not sought or voluntarily provoked by the offender as an excuse. B. The provocation is not given by anything done in obedience to the law. or by a public servant in the lawful exercise of the powers of such public servant. C. The provocation is not given by anything done in the lawful exercise of the right of private defense. D. Time to cool down his angry mind is not given to the offender, meaning that there is no gap between the provocation and the act. E. The person is acting upon the person who is the cause of such provocation. The second exception is exceeding the right of private defense. The right of private defense is given under Section 96 to Section 106 of the Indian Penal Code as general exceptions, but when someone exceeds these exceptions, then they fall under this category. The person acting in private defense must provide defense on a proportional basis. That is to say, if a person is threatening the other person to beat him with a lathi, then the other person cannot shoot the person in the chest. It is highly disproportionate. The third exception pertains to a public servant exceeding his power. The public servant must not, while acting in good faith, exceed his power and kill the other person in the name of justice. Hence, he will fall under culpable homicide. The leading case of Dukhi Singh versus State provided the following points. 1. The offence must be committed by a public servant or by a person aiding the public servant. Second, the public servant commits the act in discharge of the official duty. Third, he should have exceeded the powers given to him by law. Fourth, the act should be done in good faith. Fifth, the public servant should have believed that his act was lawful and necessary for due discharge of his duties. And sixth, he should not have any ill will towards the person whose death was caused. The next exception is pertaining to sudden fight. The word fight refers to exchange of blows and not merely a verbal quarrel which is without any deliberation or prior determination to fight. This exception is available in free fight, that is, fights in which there is not certainty upon who started it. The next exception we will take up is consent. This ascertains a scenario wherein the deceased, who is a major, has freely and voluntarily consented to his or her death. Now we will come to the practical and procedural aspect of murder. There are 4 stages of determining whether it is a murder or a culpable homicide. The first stage we determine if the act of the accused has caused the death of the victim. In the next stage, we determine that whether or not the said act shall account to culpable homicide under Section 299 of the Indian Penal Code. In the third stage, we determine whether the act will satisfy the 4 essentials of Section 300 or not. And in the last stage, we ascertain if the act satisfied any exemptions under Section 300 of the IPC or not. If it falls under those exceptions, then it's a case of culpable homicide, otherwise it will amount to murder. Murder is punishable under the provisions of Section 302 by death or imprisonment for life and or fine, while culpable homicide not amounting to murder is punishable under Section 304 by imprisonment of life if with intent to cause death, or imprisonment up to 10 years for either intent or knowledge and or fine. Schedule 1 of the Criminal Procedure Code lays down the offence of murder as a cognizable offence, that is, the accused can be arrested without a need to furnish a warrant. For murder is a cognizable offence, and in light of the said schedule, it is enlisted as a non-bailable offence, implying that the bail of the accused is not a right but a special grant as envisioned by Section 437 of the Criminal Procedure Code. Section 41 of the Code of Criminal Procedure governs the arrest of a person accused of murder, and one needs to be aware of the guidelines as issued in the case of D.K. Basu versus State of West Bengal in context of rights of an accused person. A person arrested without a warrant is to be, as per section 56, read with section 57 of the Code of Criminal Procedure, presented before a magistrate having competent jurisdiction within 24 hours of his or her arrest. A police officer, once finished with the investigation, is to forward a police report under section 2 subsection R of the Criminal Procedure Code to the magistrate of competent jurisdiction as under section 173 subsection 2 of the Criminal Procedure Code. The offence of murder falls within the category of a warrant case. In light of section 26, read with schedule 1 of the Criminal Procedure Code, a court of sessions is recognized as a competent court to try all the matters related to an offence formed under section 300 of the Indian Penal Code, which is valid only once it is committed by a magistrate to the court under section 209 of the Criminal Procedure Code. Since this said offence is also punishable by death of the convict, section 28 subsection 2 of the Criminal Procedure Code states that the said death sentence by a sessions judge or an additional sessions judge is to be confirmed by the High Court to competent judicature. Thank you for watching our video. If you liked the content and found it interesting, do like, share and comment and keep following Lexura Law Journal.